everyone. Today I want to introduce the Beam versus Stewart case. The content of this presentation include facts, issues, analysis, and conclusion. Now let's first look at facts. In this case, the plaintiff is Monica Beam, who is a shareholder of MSO Incorporated, and the defendants include Stewart, the director and founder of MSO, and all other current directors and a former director of MSO. Here are some background facts about Stewart and MSO Incorporated. MSO is a Delaware corporation that operates in publishing, television, merchandising, and internet industries, marketing products bearing the Marshall Stewart brand name. Defendant Stewart is director of MSO and is founder, chairman, CEO, and MSO's majority shareholder since he controls roughly 94.4% of shareholder vote. Stewart is a former stockbroker and is known as a household icon. So the market for MSO products is uniquely tied to the personal image and reputation of Stewart. Stewart has a long-standing personal friendship with Waxel. Waxel is the former CEO of Imcron. Waxel and Stewart had provided one another with reciprocal investment advice and assistance, and they share a same stockbroker. The speculative value of Imcron stock was tied quite directly to the likely success of its application for FDA approval to market the cancer treatment drug Abitus. On December 26, Waxel received information that the FDA was rejecting application to market Abitus. The following day, December 27, he tried to sell his own shares and tipped his father and daughter to do the same. Stewart also sold her shares of Imcron on December 27. After close of trading on December 28, Imcron publicly announced the rejection of its application to market Abitus. The following day, the trading price closed slightly more than 20% lower than the closing price on the date that Stewart had sold her shares. Then these events were found and disclosed by news agencies, and Stewart discontinued her appearing in public to avoid answering questions about her sale of Imcron shares. After barely 2 months of such adverse publicity, MSO's stock price had declined by slightly more than 65%. In January 2002, Stewart and the Marshall Stewart Family Partnership sold 3 million shares of MSO's Class A stock to an investor group, ValueAct. Now, here comes to the issues. There are 2 issues in this case. The first one is that Beam alleged that director defendants of MSO breached their fiduciary duties by failing to ensure that Stewart would not conduct her personal, financial, and legal affairs in a manner that could harm the company, its intellectual property, and its business. The second issue is that Beam alleged that Stewart breached her fiduciary duty of loyalty, usurping a corporate opportunity by selling large blocks of MSO stock to ValueAct. Now let's do some analysis. The key question for the first issue is that whether or not directors of MSO breached their fiduciary duties. The duty to monitor has been litigated generally where directors were alleged to have been negligent in monitoring the activities of the corporations, activities that led to corporate liability. However, in this case, plaintiff alleged that the board has a duty to monitor the personal affairs of an officer or director. The Delaware Supreme Court held that regardless the Stewart's importance to MSO, she is now the corporation, and it is unreasonable to impose a duty upon the board to monitor Stewart's personal affairs because such a requirement is neither legitimate nor feasible. So the answer to this question is no. The key question for the second issue is, did Stewart breach her fiduciary duty, usurping a corporation opportunity by selling large blocks of MSO stock to ValueAct? There are 4 basic factors for establishing usurpation of a corporate opportunity. In this analysis, no single factor is dispositive. All factors must be balanced as they apply to a particular case. So let's look at these 4 factors one by one. The first factor is the corporate is financially able to exploit the opportunity. In this case, MSO was able to exploit this opportunity because the company's certificate of incorporation had sufficient authorized shares of Class A common stock to cover the sale of value add. So the first fact is met. The second factor is that the opportunity is within the corporation's line of business. In this case, MSO is a consumer products company, while value add is an investment company. So the second factor is not met. The third factor is corporation has an interest or expectancy in the opportunity. In this case, plaintiff Beam does not allege any facts that would imply that MSO was in need of additional capital, seeking additional capital, or even remotely interested in finding new investors. So the third factor is not met. The last factor is by taking the opportunity for his own, the corporate fiduciary will thereby be placed in a position inimical to directors' duties to the corporation. Given that MSO had no interest or expectancy in the issuance of new stock to value add, Stewart's sales did not place her in a position inimical to their duties to the company. So the last factor is not met. Additionally, Delaware court has recognized a policy that allows officers and directors of corporations to buy and sell shares of that corporation at will, so long as they act in good faith. So only one of 4 factors is met and 3 other factors are not met. On balancing the 4 factors, Stewart did not usurp a corporate opportunity for herself in violation of her fiduciary duty of loyalty to MSO. Based on analysis, we can come to the conclusion. Stewart and all other directors of MSO did not breach their fiduciary duties. These 2 courts are dismissed. Thank you.